G'day, Kim. How are you?
Hi, Andrew. Back again.
We are back again. Your favourite time of the week.
I know.
It's a short week, isn't it? I can't forget. Isn't it just great having a break?
It is. It was very, I must admit, as much as I love work, it was very hard heading back home on Monday afternoon.
Yeah, look, I'm the same. I work is what wakes me up, but I didn't want to wake up.
No.
I was lying in bed going, maybe I could take an extra half an hour. Look, today we're going to talk particularly about a coronial inquiry into what was described by the coroner and accepted by the relevant hospital as a toxic culture. I'm just going to give you a trigger warning now when we talk about it. This does refer to the death of a person as a result of that. So when we come to it, I'll remind you again. But the importance of this coronial finding, which is publicly available, reminds us of what would happen if it wasn't 2018, but it was now and this occurred. There'd be people in jail around this.
Yeah.
So the reason we're talking about it today is obviously to explain this is not an unfamiliar work setting. The thing we're talking about in your work is compensation life, things you've seen a million times.
Yeah.
What I'm putting on the table for is this is now would probably be prosecuted as a reckless endangerment or workplace manslaughter. And I just want you to think about that as we come towards it. But why don't we go on to our first case, which is the Tyson Wood case.
Okay.
Now, Kim, what do you know about this?
Okay. More than you, I'm guessing.
No, I know about this wage.
Yeah.
There's the high income threshold case.
So a director of a company, he was over the high income threshold. The company argued when they terminated him that he wasn't protected from unfair dismissal because he was over the threshold.
And just for people who don't understand that, if you're over a particular high income threshold and you're not part of an enterprise agreement or award covered, then you don't have access to the unfair dismissal regime. Still do for general protections, but not to the unfair dismissal. So that's what this case was. He was over it by several $1,000s on his base rate of pay, but something happened.
So he took a salary cut in order to help out the company when it was going through some financial difficulty. And so that was effectively a wage loan that he would be repaid contingent upon the company doing better financially. And because they weren't able to determine how much he might be repaid, when it would be repaid, and if he would be repaid, it couldn't form part of his salary.
And he was terminated actually after they allowed him to look for alternative work because there was so little money within the business.
That's right.
So yes, they failed, and the unfair dismissal regime. This is a jurisdictional argument, so the unfair dismissal regime continued to apply. What I thought we might do is move on to the next case. Interesting time to be talking about injunctions and in talking about restraints, given the fact the Labor government have talked about a threshold of $175,000 as being the limit under which you can have a non-compete clause. And strangely, before the Victorian Supreme Court, an injunction was sought in the International Cleaning Services case for a person who resigned and went and worked for Vivid.
For a competitor?
Called Vivid. Then not only solicited a client, but also a person who worked there.
Tried to poach a former employee. Colleague.
They got the usual lawyer's letter and they poked and shoved for a period of time before bringing an injunction, rather than bringing an injunction immediately. And they sought an injunction to cease his employment with Vivid to prevent him using confidential information and from poaching or soliciting
clients and staff.
That's right. And in the end of it, which I thought was a great decision, is the Victorian Supreme Court's an incredibly good place to go and try and get an injunction because it is the ultimate sort of test for you. But what they said is, look, you can't come here arguing irreparable harm when you've delayed. And in injunction terms, irreparable harm is a jumping point to say, I'm going to stop your employment where you are because you're too dangerous there. And they said, well, we're not going to allow an injunction for that because you've allowed delay. In law terms, that's called laches, where delay shows it can't be that serious. But we are going to give you an injunction in respect to the solicitation, and we are going to give you an injunction in relation to the misuse of confidential information. So there was a bit of a win-lose. But interestingly here, what it shows is this arbitrary level of 175, which is introduced purely on policy terms, doesn't recognise where risk actually sits. And really, restraints should apply where someone holds the goodwill of a business. They shouldn't be able to apply where someone's a secretary or someone's a junior lawyer. But somebody at your or my level who holds clients of the business in their hands. Clearly a restraint's a reasonable thing to have.
Yeah.
So, look, we did it just for fun, didn't we? We put it up there because I just wanted to poke a bit of fun at a policy which shows that 175,000 isn't a test. It's the ownership of goodwill and the misuse of that goodwill.
That's correct, yeah.
Right, let's go on to the next case. This is Stockwell. Each year, isn't it? Going to the toilet before work and it's not compensable. Give me a break.
Yeah, I know. And I can't believe the regulator kept fighting this one. But anyway, short factual situation. Lady started work at 9 a.m. In order to prepare herself for her working day, she was going to the toilet, slipped, fell, injured herself.
8:45 a.m.
At 8:45,
Yeah.
And the regulator in Queensland argued it's not compensable because it didn't arise out of or in the course of her employment.
Because it was a choice before she arrived. She could have done it at home, she could have done it here. What absolute nonsense.
So, look, there's lots of cases about injuries that occur outside of the workplace.
Yep.
And I think, just to give you an example, if I leave the office at lunchtime to go and get a sandwich and I trip over a curb, that's compensable.
Yep.
If I go down the street and do rock climbing in my lunch hour, that's not compensable.
Do you?
No. Do I look like I do?
You don't look like a rock climber in a minute.
But if you said to me, Kim, we're doing a team building exercise, we're all going to go rock climbing at lunchtime, you need to come, and I get injured, that would be
Or even if I
compensable.
suggest it's important that you were there.
Yeah.
Yeah. And what this case really talked about is you can't get around the ordinary habits of a human being.
Yeah.
So that's the words they use.
Yeah.
If it's going, you normally have lunch at lunchtime, well, that's going to be compensable. If you need to go to the toilet before or immediately after, it's going to be compensable.
Yeah.
And I guess neither of us really understood why this case was ever run, because what it shows is the ordinary course of business is an expectation of what you do as you're arriving at work, what's going to happen as a human being who comes. They're going to go to bathrooms, they're going to get a bite to eat, they're going to get a coffee. All those things, they're compensable.
Yeah.
And I think we just got to be a bit wiser about having fun. I was stunned the regulator wanted to pull this fight.
Yeah. The manager supported her too, though. That's the funny thing. The employer actually supported her claim. The regulator didn't.
I didn't know that. There you go. I'd only read half the case, just like usual. No wonder you're laughing at me. Okay, the next case is a reckless endangerment case. It's a case which...
Well, it's an appeal against a fine for reckless endangerment because the fines were so much higher than what had
They were
previously
110.
been.
No, not only that, also against the director.
Yeah.
So, and it was against the actual criminal sanction, which is the 600 unpaid community service orders, which actually was successful at the end of the day and was commuted to a lesser amount. But the part that interests you and I, and particularly Nina and I, was $2.1 million was 110% higher than ever been awarded before for a set of facts which, if we use negligence as a term, wasn't excessively negligent. Compared to a lot of things, it was at the mid-level of seriousness, but the nature of the injury was terribly serious. Yeah. It was a long mechanical lathe where a person got struck with a bar that shouldn't have happened. Terrible head injuries. The thing about reckless endangerment is, and the courts repeatedly say it, the seriousness of the injury goes to the punishment in reckless endangerment. Not quite so much in primary duties, but particularly in reckless endangerment because of the subjective knowledge of the risk of serious injury. So when you charge someone with reckless endangerment, you've got to demonstrate that there was a subjective knowledge of the risk of serious harm and then you took no reasonable steps or inadequate steps or were careless or indifferent as to the controls you should have had in place. Yeah. So this is pretty important because we had the industrial manslaughter, the workplace manslaughter case the week before from the Court of Appeal. Priestley's very senior judge was, as a barrister, safety barrister, $3 million, low to middle level workplace manslaughter, which means normal workplace manslaughter where there's really serious negligence, $5 to $6 million will be the tariff. Here we've got a mid-level reckless endangerment where $3 million is the top and they've gone to $2.1 million. We're going to see under the sentence advisory reckless endangerment go up to 10 if it's accepted in Victoria. I think we're going to start to see some very, very serious fines coming forward. The Victorian and New South Wales Court of Appeal are probably the most respected courts of appeal in safety across Australia. Victoria Court of Appeal is leading a bit in this process because the expertise that sits in that Court of Appeal around safety. And I think for the rest of Australia, this is a wake-up sign that if you commit a serious wrong as an individual, reckless endangerment, you'll get more than community service orders. You'll go to jail, and we've already seen that in Queensland. We've seen it here with Jackson, 12 months. But for workplace manslaughter, there's going to be serious jail time and fines in the $5 to $10 million, not fines $2 to $3 million, which was the previous sort of limit. So I think the reason I've put this case in is I think this shows where the tariff is going. And the tariff is what courts would expect to order. You know, what are the limits, upper and lower tariff? That's jumped dramatically based on this case, which is Dennis Jones Engineering, and also L&M, which was the last industrial manslaughter case. Labour hire, Gelwatech is the case we're going to talk about. Interesting case again, because I think when people use labour hire, they think they're carving out liability.
No.
And in Gelwatech, this is a forklift incident where there'd been no induction and training around the forklift use. The person who drove it was somebody who was unskilled, was in the car park area of Gelwatech, and they end up getting a $225,000 fine, I think it was. But the importance, again, of this case is to show you that whoever is on your site, you're responsible for, whether it's a student, whether it's labour hire, whether it's a contractor who's on your site. The only difference with the labour hire is there are two different responsible parties. The labour hire provider is liable for the safety of that person and would be liable in these circumstances, but undoubtedly the host is liable unless they can demonstrate there is a proper system that does everything that's reasonably practical. That is, that it identifies the relevant hazards, it determines the risk, and there's controls in place to prevent it, then supervises and prevents that from occurring. So it's a really discrete case, but I think for Nina and I, recently we've dealt with students and labour hire where problems have arisen and people keep thinking they're protected because they're not their employee, and the answer is that's not the case in any jurisdiction in Australia. Discrimination law and beards.
Interesting one, this one, because factually, prison guard had religious belief, wanted to grow a beard and said, I can't wear respiratory PPE. Because I need to be clean-shaven. I don't want to be clean-shaven on account of my religious beliefs. The employer had provided exemptions to previous religious groups, other religious groups, Muslims and Sikhs. And I was really impressed with this case, actually, how far they went to investigate the request for exemptions from the PPE policy. And they got evidence from the Central Religious Organisation to say, no, it is an essential part for a Muslim and a Sikh to wear a beard. Whereas this case, it was a preference, not an absolute requirement of the religion. And so they rejected his exemption application and he filed a discrimination claim. And he lost. And he
lost because two reasons. One, the primacy of safety law. So when you look at the costs of actually meeting safety needs for a person with a religious exemption is quite profound. And also, exemptions create complexity in a workplace around safety. So when you do an exemption, it is an administrative and business cost to do it. This was not part of the organised religion's requirement. This was an individual flavour or taste that a person had who believed in, and it was rejected, and the courts found no discrimination, that it was reasonable what was done in the circumstance. I thought it was a great case.
It was.
We're going to talk about Ballarat Health Services and the coronial inquest that occurred. And once again, if I can just remind you, we are going to talk about the death of a person in this. And if you,
by suicide, I think it's important that we mention that.
And if you're uncomfortable, please don't watch further from it. All right, we'll give you a chance. We'll now move on. This is pretty troubling. I read the inquest findings. This was a woman who worked in the accounting area. She'd had a pretty dreadful experience over a prolonged period of time. There was no doubting that her mental health had declined. She put in a workers' compensation claim. That was accepted. On her return to work, her new boss was aggressive. That was her view of it. When the coroner came in to investigate, because when she did come back to work away from pre-injury, back to full pre-injury duties, she was immediately given a job which was highly complex, and shortly afterwards she took her life. When the inquest was being undertaken, there was an acknowledgement by Ballarat Health Service that this area was a toxic area, that it was full of favouritism, that there had been not only unkindness but aggression, rudeness, a range of behaviours which were just abominable. And they weren't just one-offs, they were a whole culture of it.
Yeah.
The tragedy of this is that a person lost their life, and I think we need to stay at that and say this is what happens when you treat people in a cumulative, awful manner over a period of time in an organisation which is unforgiving. And I think that is terrible, and people should understand that psychological hazards is not a nice phrase. It's not yogurt and yoga. It's too easy to trivialise it. This is an example of what it's really like when it does get out of control, and this is the impact it has. But the reason I'm raising this case today is not because of any of that. It's to say, we've just talked about two cases, one reckless endangerment, one workplace manslaughter. This is at the high end of a workplace manslaughter. Okay, this is where there is a state of knowledge inside an organisation of a highly dangerous culture that hurts people, where there's abundant evidence that people are being hurt and that the vulnerable person has been hurt and deserves care and is not given that care. I think that's middle to upper level industrial manslaughter. I think to the relevant person who was responsible as an officer and had the knowledge of that, there's a risk of jail. But for the organisation, the fine's in the $4 to $5 to $6 million. And I think that should, as you hear this, you should take it away as an organisation and go, do we have any pockets that are like that in our organisation? Are there people who behave badly? Because it started off by people behaving badly a little bit, was condoned, and then they built cliques of people who could behave badly, and that was condoned. The trajectory is really well known. We all know it because we all went to school. We've all seen it at school. We know what it's like at work. But in this case, we're leading towards the death of an employee, and I think towards the imprisonment of somebody and really serious fines. So there's not a lot more, I think, that we can say about it other than this is a terrible tragedy, but it highlights the difference between 7 years ago and now, because 7 years ago nothing happened. There was an improvement notice issued. That's it. Now there would definitely be reckless endangerment prosecution. If we look at the VBA case, an example of a prosecution for much lesser, although that involved death as well, but for much lesser behaviour, much lesser corporate risk. This is profound risk, and I think would probably go higher than reckless endangerment, and we'd see industrial manslaughter. So why don't we go and test that a little bit on the case study? And again, the case study has similar risks. So again, it relates to suicide. So if people could just be mindful of that before they proceed further.
Okay, thanks, Andrew. So Rachel was a project manager at Super Duper Design. Her role involved designing air conditioning systems for large commercial premises. Sammy was the CEO. He was the son of Ted, the original owner. Sammy had grown the business by heavily leveraging it through debt equity. His father had been a direct, simple man who built a successful business through strong relationships with major commercial builders and a team of hard-working men and women. It was a tough but close-knit culture, and that culture changed under Sammy. Sammy was mercurial. He liked to use the consultants from major firms, micromanaged everything, and his emotional volatility meant that few dared to challenge him. The project consisted mostly of people from firms like Deloitte and PwC. They were high-performing, hard-working and driven to succeed, but none of them were used to Sammy's management style. It caused significant stress as he would frequently change direction, assign blame, act rudely and aggressively, and never offer praise or rewards. Rachel had led the team working on large public enterprise projects. She had successfully secured tenders for major initiatives and was well respected in the business community. She was direct, honest and deeply committed, but Sammy had worn her down. His emails arrived at all hours of the day or night, often critical and blunt in tone. His phone calls were filled with bluster and harsh criticism, and his expectations were often unrealistic and unhelpful. Rachel's marriage was falling apart. She couldn't sleep. During the most important pitch of her career for the Melbourne Arts Precinct refurbishment, Sammy pulled staff from her team. One day she collapsed at her desk. Struggling to breathe and overcome with emotion, she fell to the ground. Her team gathered around her and she sat crying and visibly distressed. She went home and saw a doctor who diagnosed her with severe anxiety and confirmed that she had suffered a panic attack. The doctor prescribed rest, sleeping tablets and anxiolytics.
Anxiolytics, yeah.
Thank you. Anti-anxiety medication would have been so much easier, Andrew, but anyway.
No, it's my health background.
Sammy heard about the incident and expressed concern. However, when Rachel didn't show up to work the next day, having overslept due to the medication and failed to notify the office, he sent a text message, "Sorry about yesterday, but if I don't hear from you in the next hour, I'll have to get someone to take over." When she read the message, she collapsed onto her bed, overwhelmed by despair, and terrible thoughts entered her mind. The following day, she returned to work, having sent Sammy a doctor's letter explaining that she was emotionally fragile, needed care, and was suffering from serious psychological issues that needed care. In her email, she told him that she would return to see the project through, but would require time off afterward. Sammy attended the team meeting that morning. Her colleagues greeted Rachel with kindness, hugging her and offering warm words. When Sammy walked in, speaking loudly, he said, "As you know, Rachel is mentally knocked around and can't lead the team at the moment, so I will. She's struggled with timelines and the stress of the job, so from now on you all report to me. Rachel, just take it easy." While perhaps meaning to be supportive, Rachel was devastated. She sat in the restroom, staring into space, consumed by dark thoughts.
So question 1, does Rachel have a workers' compensation claim?
Undoubtedly. Yeah.
I'm sorry this was a long one, but I had to get all the facts in there.
Yeah.
Okay, does Rachel have a general protections or discrimination claim?
Yeah.
Yeah, I mean, there's no doubt at all. She's raised questions around her health. That's a protected attribute under general protections.
Yeah.
So, yep.
Discriminated against her for a disability by taking staff off her.
All those things.
All that.
Okay, is there a safety prosecution risk here, and if so, against whom, and what would the sentencing be? I think it's pretty obvious that it's against the business and Sammy.
Yeah.
What's the nature of the risk? It's clearly reckless. So Sammy is aware of the risk of serious harm. He has personal knowledge of it. His knowledge is attributed to the organisation, so they're both at that stage of having knowledge. And they were indifferent to it. The actions they took didn't seek to control or prevent that level of risk. In fact, it provoked that level of risk, which probably means that Sammy is borderline workplace manslaughter, and so is the organisation.
If she were to do something.
Yeah, if she were to do something.
Which
I guess, hasn't. And if Rachel dies as a result of her treatment by Sammy, would anyone be prosecuted? And
Same again.
And that's what I'm talking about. If were she to die as a result of what occurred, I think there is a better than 50% chance that Sammy would be charged with workplace manslaughter in Victoria, industrial manslaughter elsewhere, and I think so would the business. Well, there you go.
That's it.
That's it for today. Thank you very much. That was a tough day because we dealt with some really difficult issues, and I think from time to time it's really important we do, that we do actually talk a particular truth which is hard to hear, but I also want to know, and that everyone to know in that truth, there are really dire outcomes as well, not just for family and the person who suffered, but for those who did the wrongdoing.
Yeah.
All right, Kim.
All right.
Love
Thanks,
you to have you
Andrew.
back. Cheers. Bye-bye.
Bye.